whether their status is full-time, part-time, so it's a broader category, eligible to take 2 weeks of paid sick leave, again, related to COVID-19, whether it's due to shelter-in-place orders, the illness of the employee, him or herself, or a family member. One thing I wanted to mention as the outset is there are some exceptions or exemptions to these paid leave requirements that would likely apply to many of the chiropractic practices on the call. The first is the exception for small businesses. So if you are a small business with fewer than 50 employees and providing these paid leave provisions would jeopardize the ongoing viability of the business, you are eligible to be exempted. We would recommend that you document that somehow in case it were ever questioned, that you have a written documentation that you're a small business and it's not financially feasible for you to provide this. The next category of exemptions that would apply to chiropractors as healthcare providers is the exemptions for healthcare provider employers. So again, understanding that healthcare providers provide a sort of uniquely important service to society, there's an exemption allowing employers to choose, and it's on the employer to choose to decide that their employees need to come to work because they're in the healthcare arena. So as you're looking through this and the requirements, just have in the back of your mind that there are exemptions that may apply to your particular practice. If you believe that's the case, you'll want to be sure to document them in writing. So to start with the first of the two components of the Families First Act, emergency FMLA, then we'll do the paid sick leave. The emergency FMLA expands the Family Medical Leave Act from 1993 to allow eligible employees to take FMLA for a qualifying need related to a public health emergency. Those employees, in order to be eligible, one, they can't be employed by an employer who has applied an exemption, but they also need to work with that employer for 30 days. In terms of what's a qualifying need related to public health emergency, and we can move on to the next slide. That qualifying need in the context of FMLA is unavailability of childcare. So if the employee has a minor child, so a child under 18, or an adult child with a very severe disability that would require them to need that care, is unable to work because the school is closed, the daycare is closed, the child care services are otherwise unavailable, then they would qualify for that FMLA leave. One issue that we've had come up a lot is, what constitutes your son or daughter for purposes of leave, and it's a biological child, an adopted child, or a child where you have legal rights or legal custody of that child. So a niece or a nephew that you're really close with, but you're not legally the guardian of the child would not apply. Similarly, a grandchild would not apply. So if you're receiving these requests and they're not for the biological child, you'll want to ask if that employee has actually a legal, guardianship or parental relationship with that individual that they're requesting leave to care for. We can move on to the next slide. In terms of so if you have an employee that's requested emergency FMLA leave and you've determined that the employee would qualify and that the employer itself is not exempted, then in terms of how to calculate that family and medical leave, the first 10 days of emergency FMLA are unpaid. This time period an employer can allow, but not require, an employee to use other types of leave to make up that gap to cover those first 10 days, One very likely one will be the emergency paid sick leave that we'll discuss later, but also any type of unused, PTO, paid sick leave, can be applied to offset this 10-day unpaid period of emergency FMLA. For the remaining 10 weeks, unlike traditional FMLA, it is paid the remaining 10 weeks of that 12-week total period. And it's to be paid at 2/3 of the employee's regular salary, up to $200 per day and $10,000 in the aggregate. So as you can see, the cap is fairly low for a, certainly a chiropractor would run up against that cap if you're the employer and you have employed chiropractic staff and you've decided that they would qualify for this leave, they would run up against the cap. In terms of calculating the cap, we'll discuss later, but there are tax credits that can be applied and they only apply up to the cap. So certainly you wanna be cognizant of that, of understanding what would be covered by tax credits and what sort of paid leave would not.
Right. So Sarah, in other words, even though this seems like a very rich benefit, the policy behind this from Congress and the Families First Act is the taxpayers have the tab for this, right? Or at least up to $10,000 per employee. And just as a reminder, because you mentioned it at the outset, but I imagine many of our Academy members and folks who are listening today are small business owners. There are two major exceptions for this. The first is healthcare providers, and the second is businesses under 50. Is that right? 50 employees? Yeah. Okay.
Right. And it's 50 employees where providing the leave would jeopardize the ongoing viability of the business. So we do recommend you have some sort of documentation or statement that it would not be feasible for your employee, for you as the employer to provide this leave.
Right.
One other thing to mention in terms of the time frame of the leave, because emergency FMLA is sort of an extension of traditional FMLA, it expands the reasons under which one could qualify for FMLA, but it doesn't expand the actual amount of time one would be eligible. It's still 12 weeks total. So if you have, let's say, an employee that just came back from a major surgery or from having a baby and has already used up their 12 weeks of FMLA, once those 12 weeks are used up, that's it for purposes of FMLA. It doesn't add another 12-week period. In terms of job protections, similar to traditional FMLA, you would be required, once an employee returns from their emergency FMLA, you would be required to return them to the same or a similar position. There are some exceptions for smaller employees, some more flexibility for employers with 25 or fewer employees. So the next major category that we're discussing is the Emergency Paid Sick Leave Act. Unlike emergency FMLA, paid sick leave is immediately available for use by employees, regardless of how long they've been employed. And it also includes part-time and temporary employees. So you're going to have a broader category of employees that could potentially qualify for emergency paid sick leave as opposed to emergency FMLA. Although, as Rich mentioned, you do have those overarching exclusions for small businesses and healthcare providers. In terms of how the paid sick leave is calculated, so for full-time employees, they would be eligible for up to 80 hours of paid sick leave, and this is immediately, so essentially 2 weeks. If the need for leave is due to a federal, state, or local quarantine order. As Rich mentioned, the one in Georgia is going to be expiring soon. Due to health recommendations from the employer's healthcare provider that they self-quarantine due to COVID-19 concerns, or if the employee is experiencing symptoms related to COVID-19 and seeking a medical diagnosis. in that third category, it would be appropriate to ask the employee for some type of documentation to show that they are experiencing symptoms and are seeking medical care. In terms of the amount of paid leave, if it's due to one of these three categories, the paid sick leave is the employee's regular salary. Again, though, it's capped. So the caps here would be $511 per day or $5,111 in the aggregate during that 80-week or 80-hour. If the need for leave is not due directly to the employee, but is instead due to a family member, they're still eligible for 10 days of paid sick leave, but the caps are much lower. So if it's due to the employee caring for a family member who's subject to a quarantine order, unavailability of childcare, this is where emergency paid sick leave would sort of apply at the beginning of that unpaid period of emergency FMLA leave. Then compensation, the paid leave would be capped at $200 per day, so significantly lower, or $2,000 during the total of that 10-day period. In terms of the notice requirement, and this has been a bit of a challenge, so the Department of Labor has posted guidance saying that employers who are considered covered employees, meaning they have fewer than 500 employees and are therefore covered under the Families First Act paid leave requirements, must post a notice in a conspicuous place, so the break room, or otherwise, make sure the notice is made available to employees. So email it out. If you have an internal website, post it at the front of that. But make this notice, the Department of Labor, one-page notice of, hey, there's the Families First Act. You may be entitled to certain paid leave under these two provisions. Make that known to employees. The challenge is that, particularly for healthcare providers, a lot of your employees are going to be exempt, even if the small business exemption doesn't apply. And so what we've been recommending is that under the law, you're required to post this notice from the Department of Labor. If you don't have the notice, you can go on the website. There's a link to a one-page form you just print out and stick up on the wall or email out to employees. So you do have to post the notice, but we recommend sort of supplementing that with an additional one-page notice saying, hey,